Okay, good afternoon, everyone. If you don't already know, my name is Trent Buatte. And before I leave Germany forever, I thought, well, not forever, but this lovely institution, I thought I would contribute to the academic conversation with my own law after lunch, kind of based off of my own interests as an American lawyer and some research I did with Professor Tietier on the TTIP, or Transatlantic Trade and Investment Partnership proposal between the United States and EU. I looked primarily at empirical research into trends from NAFTA as well as international dispute settlement in general. So today is mainly focused on the NAFTA agreement, or North American Free Trade Agreement, disputes brought by individual investors against the states, what's known as ISDS. I will briefly cover the history of NAFTA. It's like literally in 30 seconds, hopefully. Spend a lot of time talking about empirical trends, and then challenges that many people have brought up, particularly in light of natural resources and environmental cases that are now up and coming, and not just in NAFTA, but all over the world, is a challenge for investor-state dispute settlement. So to begin, what my goal today is to look at two common hypotheses or challenges to ISDS and use NAFTA as the framework for that. That is, one, personal to my own heart, is American claim culture, that American investors are overly litigious, and you should be afraid of American investors taking your country to arbitration and basically squeezing you for as much money as possible. And then the second one is that arbitration discourages progressive policy making, what's known as regulatory chill. But I could summarize these in two ways. One, who brings the types of claims, and who wins the claims, and why do they win the claims when they do. Because on the surface level, these two things are true. Americans do bring an absolute number of cases, more investment disputes than any other nationals. And there are some basic surface level examples where investors have been able to challenge environmental laws. But upon closer examination, neither of them holds any water. So quickly, what is NAFTA? As I said, the North American Free Trade Agreement. Hopefully everyone in this room already knows that. Don't need to explain that. It entered into force in 1994, immediately eliminated 50% of all tariffs on Mexican exports, like all exports, and 30% of US exports into Mexico. It's estimated by now it's almost completely eliminated them. There is, however, some controversy over NAFTA, particularly around jobs and being swept from Canada and the United States and being funneled into Mexico because of cheap labor. That's what we have here. Maquiladoras are these manufacturing facilities right on the border of the United States, located in Ciudad Juarez and Tijuana. I can't forget Tijuana. And it's estimated that, depending on who you look at, 700,000 American jobs have been moved to Mexico because of this, like just across the border. And in addition, along with that comes complications with massive amounts of violence across the Mexican border and the treatment of workers. And so, does NAFTA perpetuate that? Is discussion for another day. But Just this is the context in which discussions about NAFTA are taking right now. There have been huge trade surpluses for both Mexico and the US since 1994, linked directly to NAFTA. Most experts think there's been either negative or barely positive impacts for Canada. So they're the like redheaded stepchild of NAFTA. They kind of, in terms of economics, didn't get much out of it, is the assessment now. What I will be focusing on is investor-state dispute settlement. Chapter 11 allows individual investors to file claims against the entire country for your typical things of investment agreements, national treatment, most favored nations, fair and equitable treatment, just a subpart, and then expropriation without compensation, among others, but those are the main ones that are usually raised in Chapter 11 disputes. Of course, you're always allowed to choose between ICSID or the UNCITRAL rules, and then one thing that was new in 1994 that NAFTA made sure to say was that all final arbitration awards are enforceable within the domestic courts of the US, Mexico, and the United States. Why am I focusing on NAFTA? This international investment agreement has given birth to more ISDS cases than any other individual agreement. Within the spaghetti bowl of investment agreements, bilateral investment agreements make up a large majority of that, but this one agreement far exceeds all the others as being the source of law. Second, after that is the Energy Charter Treaty. So it's a good petri dish for looking at what happens with ISDS and are there any common trends we can see. Which brings me to ISDS trends. So I literally went through every single case filed before NAFTA tribunals, either through ICSID or the UNCITRAL rules, coming up with 74 cases. A handful of them were never even pursued after they made an initial claim, but you can say that 74 cases have been filed using NAFTA Chapter 11. So 29, as I said, are inactive or withdrawn. They never even established a panel whatsoever, or some cases were withdrawn after they established an arbitration panel. But most of the time, investors realized that they couldn't win, or that there were other ways to get what they wanted, or that international arbitration was simply too expensive to continue with. 20 have been dismissed, either on jurisdictional grounds, a few on the merits. 4 have been settled, all 4 of which I think belong to Canada. Canada has settled 2 of them without paying anything, and then notably has paid out as much as $130 million to one company for a settlement. But in comparison, the company was asking for $500 million. So could argue they got off easy, but then we have, out of 74 cases since 1994, only 8 investors have ever succeeded in their claims against Mexico or Canada. And I say that because no one has ever won a case against the United States. So 8 have been found in favor of the investor. Mexico is usually on the losing end of this. 5 cases have been found against Mexico. And there are 12 currently pending. So among all of my empirical research, I would say, rather than analyzing the law, I tried to categorize what areas these types of claims were challenging, to find out, is there a commonality among these claims that investors are bringing against the NAFTA countries. So you can see the number one cause is natural resources and the environment. Natural resources, these two categories, it was hard in a lot of cases to figure out which was which. This was just my own personal call on which was which. A lot of the natural resources cases come from timber disputes over logging between the United States and Canada. It produced a ton of cases of investors both in the US and in Canada. And so that is why it's kind of an inflated number for natural resources. And environment, that could be anything from a ban on pesticides to, we'll talk about a case today about wind energy. Was the reason for that case was an environmental assessment, not the energy itself. So coding these was just my personal call and how it came out to see if there was any prevalence in the kinds of claims that people were making. What I found more interesting, though, is the kind of thing that people were challenging. Not necessarily the subject matter, but are they challenging literally a law that a country passed or a province or a state passed? Or is it an administrative decision or even a court decision? And the vast majority challenge administrative decisions, so about a specific company's permit being revoked, or an agency of a government deciding to recategorize a pesticide, for example, which therefore then prevented import or export of that pesticide. There is, however, a significant amount of cases that directly challenge something because of a legislative decision that was made. Now these are just the claims that were made. We will see later that this is important for the ones that succeed, because all the ones that succeed are in this category. Oh, that was cool, but weird. All of them are in this category, and none of them are in this category. So that may allow you to make conclusions, as I will state later, about what kinds of claims are succeeding under investment disputes. So as I said, what are these successful claims? I call successful claims ones that the investor actually wins in front of the investment arbitration panel. And then also, you could consider a win when the government settles with you and pays you money. So, for example, the investment tribunals actually, when it is fully adjudicated, award not that much money to investors. So SD Myers got $6 million against Canada. Pope and Talbot won their case, except they got less than $500,000, versus when Canada has settled, they settled for $20 million with Ethel and 130 in the largest settlement with, my favorite word, Abita Bowater, which I will talk about later, and why this settlement is so big. Because there's significant controversy about investor-state dispute settlement and allowing one investor to essentially sue a country and get large amounts of money, larger than they would in domestic court, for example. But I will explain later, the few instances where there are huge awards are usually merited, I would say, or the country was willing to settle for it. And then Mexico has lost 6 cases for a total of $187 million. But literally, I found, when I looked at this, 90% of all the damages came from one instance, which was this trade war back and forth between the US about high fructose corn syrup versus cane sugar being used in soft drinks. Also, that went to the WTO, known as the Mexico soft drinks case, and was a pretty obvious case for protectionism. And so all 3 cases were pretty easy for the panels, and all 90% of the money Mexico has had to pay to the US has been, or to US investors, is because of that one decision to start treating them differently. And all because of soda. So, one thing I was interested in doing this assessment of all the NAFTA cases was this perception around the world that American investors and Americans in general are prone to filing cases. Our first reaction is always to, go after somebody for as much money as possible, sue them in court, or people are often afraid now to sign agreements with the US because they think it will expose them to hundreds of millions of dollars of liability because American investors will just flood you with cases based on either a BIT or an IIA. And there are three ways I think you could look at this to test whether it is true, whether Americans actually do end up using ISDS more than anyone else. One is the absolute number of claims. That's pretty easy. You could also do claims per capita, although I'm not sure, I didn't even do that because I kind of don't think it's a valid reason. Instead, I think the more valid is comparing the number of claims to the amount of investment leaving your country. You would think the number of claims follows the amount of investment. If my investors from my country are investing more money, of course it's going to produce more cases. So I compared the number of claims for lots of countries to their FDI outflow from home countries. So I did some fancy graphing, and this is just what happened in NAFTA. These are claims brought by the US investors per year. And this is the trend line for across. There's an average amount around 3, or actually less than 3 claims per year since 1995 to 2012 was when the last ones were brought. At most, it's been 7 in 1 year, but it always is somewhere between 1 and 7. But you would think for the amount of money going back and forth between Canada and Mexico, which is the US's largest trading partner, that there would probably be more than 3 per year. So when you look at the averages, it isn't as much as people think it would be. And then you can compare it between US investors over here versus overall claims for all of NAFTA. So US investors have brought 51 claims total, and compared to everyone else, it kind of follows the same trend, and in fact the average number is higher for everyone. And also notice the highest year had 9 claims in 1 year, but 6 of them were brought by Canadians. So the US didn't do that year. But you also see this 1 year corresponds that the US investors brought all of the claims over here in that given year. But NAFTA never has exceeded 9 claims in 1 year. And since it's been existing. When you compare that to other systems of dispute settlement, like the WTO dispute system, or if you really want to, you could compare it to the number of cases filed at the European Court of Human Rights in 1 year is thousands and thousands compared to when one system of investors' rights is at most 9 in 1 given year. So preliminarily, I would say based off of this, it's kind of exaggerated to think that investors are chomping at the bit to use, I guess you could say chomping at the bit, that's a pun, but this isn't a bit, so never mind. But really, really want to use ISDS. It doesn't seem to be supported, at least in the NAFTA context. So I went from mapping NAFTA to comparing how does NAFTA, which is the most used IIA in the world, how does it compare to everything else going on in the world? So this is from the most recent table by UNCTAD. Long report. I just pulled out two of the most common figures. So here you have the same measure that I did over here about the numbers per year. Of course, the number, everyone likes to say the number is always increasing in the number of times investors are using this dispute settlement system overall for BITs and for IIAs. In fact, it dropped in the past year, and at most, the highest number has been 58 in 1 year, and that was in 2012. Then, the most troubling figure for me to handle is who is bringing these claims, where are these investors coming from, the home state for the investors. For all of these, you will see the United States is far ahead of everybody, more than double of the next highest, which is the Netherlands, followed by the UK and Germany, and then we have another NAFTA partner of Canada. So, preliminarily looking at that, you would say, yes, Americans are prone to bringing claims. We like using, our investors like using ISDS, and we will squeeze you for millions of dollars. One thing I did, however, was compare the US. First, you could compare the US versus all of the EU, for example. If you added up even the rest of the countries here, if they belong to the EU, they would far exceed the US number. So when you're considering TTIP, for example, EU investors are actually more prone as a whole to going and using this system than US investors are. So it doesn't hold up for the example of TTIP. And then my thought was, of course, well, one reason the United States exceeds everyone in the amount of investment claims is because our amount of foreign investment in other countries exceeds most of these other countries here. So it would be logical to assume that claims follow the money. The more money, the more likely I am to have a dispute with another country. So I looked at FDI outflow. This information is from 2011. It's the most reliable information. So the NAFTA countries, the United States wins with $397 trillion total going out of the United States in terms of foreign direct investment. So if you compare that to their total number of claims, it's about I think it was a 1 to 3 ratio, or 1 for every $3 trillion. Compare that to the next highest, which is the Netherlands. They have a reverse ratio of 2 to 1. So they're bringing 2 claims for every $1 trillion spent overseas. So on that proportion, it would seem the US is behind them. As the same with, it also follows with this, that it's actually the same proportion in terms of number of claims brought versus how much they're actually investing overseas. And it holds true with the UK and Germany, which are the next highest when I looked at these. So at least just in this tiny measure, it seems that the reason the US exceeds here is because our foreign output is so much higher than all of these other countries, and it would make sense since we're spending so much more, investors are spending so much more money overseas, they're more likely to bring claims because of simply the amount of investment per year. Of course, this is only a preliminary look at it. Of correlation is not causation, but I must add footnotes to this as I go. Just preliminary idea from what I've looked at and from the NAFTA claims themselves, the US is actually filing, American investors file less than you would think they would. And it would seem actually Dutch investors are really prone to using this system. So my first question, and now I've answered it, is are US investors more litigious than others? No, I would say first, no more so than their foreign counterparts. So you're not more likely to be sued by an American investor than you are to be by a Dutch investor or a Canadian investor, for example. So signing an agreement with the United States does not expose you to a larger proportion of investment disputes. And secondly, that investors from Canada and EU countries use ISD more often than when you're comparing the amount of investment itself. So just a preliminary look for myself to prove that Americans are not as scary as people have made them out to be in the news. And this is actually, it may seem like a silly thing to be talking about, but especially in the TTIP conversation, I've seen this in the news over and over again. It actually appeared, the words American claim culture appeared in official documents from the UK Parliament. They have actually released, they had a report from the Parliament saying that American investors are more likely to sue than anyone else. It's also been submitted to the European Commission. People have submitted tons of things, and part of that, them opposing TTIP is that it will expose European countries to all of this flood of litigation, arbitration from US investors. And upon that, hundreds of millions of dollars. But not only is it you're not as likely to win as you think you are, and then also Europeans are just as likely to go against the US than American investors are in Europe. So that's the first question of who files these claims. The second one I wanted to answer is who wins, and why do they win? So who prevails in these cases? So part of this goes to this ultimate question that does foreign investment arbitration actually hurt public policy making in terms of stopping governments from passing things about environment, healthcare, natural resources, also known as regulatory chill? I tied this ultimately jumping through a ton of reasons, but I can tell you I found that it was associated with the type of decision they were challenging. And in fact, everyone that challenged a statute or regulation almost always lost. Everyone that challenged the law itself, passed by a parliament or a legislature, always lost in NAFTA. The cases that won or were settled are all cases that either involved obvious protectionism, like those soft drink cases, or a specific promise to that investor by the government themselves. And most of the cases involved even more than just an individual permit. It also involved something else. One individual or a government official actually promised the investor a little bit more than just their permit, or so that there was an expectation to a reliable investment in the future. And that no successful claim under NAFTA has been able to challenge a statute or regulation per se. So like the ones that have tried to challenge the law itself or their ability to pass the law have always failed. You always have to have something extra. Either the law itself is very obviously protectionist, or that the individual company or investor has something to rely on. And usually they've been able to prove specific promises from the government officials themselves. So now we're stepping out from the empirical, not very legal research, and now doing some anecdotal things into cases. So what I did was, in doing this, really looked at cases, in which cases succeeded and which failed. For example, these three arguably succeeded and this one failed, and to show why. For example, in S.D. Myers, U.S. investors challenged a Canadian ban on exports of, let's see, it was a toxic waste, I had to find the name of it, but it was officially declared a toxin by both the United States and Canada, but there was a U.S. company that specialized in treating it, so getting rid of it, and they wanted to take it from Canada to the U.S. where their facilities were, so they could treat the toxic waste. Well, the United States explicitly gave S.D. Myers an exception so they could continue doing this cross-border remediation for toxic waste. Well, the Canadian government didn't like that this one company was still allowed to operate within Canada and take it to the US for remediation. So they banned ostensibly all exports of this toxic waste. So it looked like they're banning all exports, but in fact there was only one company at the time exporting, and it was S.D. Myers. So the panel, S.D. Myers took it to arbitration, and the panel found in favor of them. Meanwhile, the Canadian government challenged it in the end in Canadian court, and the Canadian court did some digging into it more than the arbitration panel, and found evidence that Canadian companies went directly to lawmakers and told them to pass this so that this US company would no longer compete in the Canadian market. And they had quotes from people about this, proving that the only reason this export ban was passed was to explicitly exclude S.D. Myers from the Canadian market. This was an instance of pretty much pure, unadulterated protectionism. The Canadian courts even found it, and the Canadian courts had an exception for public policy reasons to allow these sorts of measures, and Canada's own courts would not allow this even under a public policy or a discretionary exception for the government for environmental reasons, because the nefariousness of the act far outweighed its actual purported environmental impact. Compare this to the Methanex case, which a company from Canada had invested in California into, I forget all of these specific let's see. Sorry. Anyway, so California, MTBE. This is yes. Which is a gasoline additive. So California decided to ban this chemical known as MTBE, which is an additive to unleaded and leaded gasoline, because they had found some preliminary evidence that this particular chemical was contaminating drinking water in California. They had preliminary evidence that it was contaminating the water, which could then lead to public health problems. So they passed a ban and moratorium, first a moratorium and then a complete ban on MTBE. Well, Methanex, it was a Canadian investor in California, and they filed a Chapter 11 claim, claiming first expropriation without compensation, and then also your usual fair and equitable treatment argument. The panel in that case got to the merits and denied it because California had a legitimate concern about public health, and they could prove it with scientific or prima facie case for scientific evidence. Comparing that to a case like S.D. Myers, there was no comparable, at least they never found anything that said that the ban on MTBE was specifically against Methanex or foreign corporations. So because of that, their claim was denied. And then to speed things up, you can compare that to Metalclad, which is a famous / sometimes, depending on who, infamous expropriation case. The panel departed from a lot of other panels, I don't know, not precedent, but prior decisions on what constitutes expropriation. But beyond the legal principles that it established, it was important for its facts, because I've seen a lot of people talking about Metalclad in reports about TTIP and US investors. And in that case, US investors had a waste treatment facility in Mexico, and they had bid on a reconstruction permit so they could start rebuilding this facility, and then an operational permit to actually operate it. Well, this is an instance where everything was approved. They passed an environmental assessment by the Mexican federal authorities. They were even told by the Mexican federal authorities, they promised them that they would get this contract in the end, and that there would be no problems. Well, the local sub-state authorities, the actual city authorities where they were, decided to deny them further permits for something else. And in order to stop them from operating it, the federal state that they were in declared all of their territory an ecological reserve, which then led Metalclad to file a claim against Mexico for expropriation without compensation. So some people have used this case to say the panel found in favor of the investor, and that it was clearly against the idea that governments should be able to establish ecological reserves or deny people permits for environmental reasons. Well, you could also argue the flip side, which was the ecological reserve was only established to get rid of this company, and as well, that they were given specific promises on which they relied, which is what I said, a little bit different than challenging the law itself. Then my favorite thing to say, a B2B Wowater, was a company in Newfoundland from the US, and they had had a contract with Newfoundland since 1905 for timber and water rights. Well, a B2B Wowater declared bankruptcy and could no longer operate their facilities in Newfoundland, so they closed their plant. basically eliminating 800 jobs locally. In response, Newfoundland specifically passed an act that actually, the law itself said it was the B2B Bowater Act. They put the company's name in the law, rescinding all of their contracts for water rights and timber rights. And the legislative record says the main reason that a lot of the people who supported it was because the company destroyed 800 jobs by closing their facilities. So the government took back all of their water rights and timber rights. And the company sued the entire government of Canada for this. And Canada ended up settling. This was the $130 million out of the $500 million that B2B Wowater wanted. Although it was settled, you can't draw any firm legal conclusions on this. It also looks a bit suspicious since the law itself that they were challenging singled out this company to rescind their permits that they had had since 1905. And the reasons for it were not related to one of the legitimate public policy reasons. Instead, were about essentially to punish them for closing their factory and making 800 people unemployed. So these are settled and done cases just to explain a little bit more about who wins and why they win. As I said, just example cases that these cases that succeeded either went after an administrative decision or there was some sort of extra promise that the government had made on which the investor relied. When they went after the law itself and saying that the law violated it, they always have lost. So if you want to be a smart investor, find a better reason when you make your claim. There are two cases on the horizon, though, that I want to briefly talk about in NAFTA that are getting a lot of attention, and they involve the environment. And this is the future of NAFTA, and how these cases are handled could provide some interesting precedent for investment arbitration and in the environment, which is a lot of people's concerns. So both actually involve permits rather than the law themselves. So in this case of Windstream, an American investor had been given not only a permit, but also a 20-year contract with the government of Ontario for 19% of all wind energy produced on the Lake of Ontario. For offshore wind energy, so big wind turbines in the middle of the lake. For some reason, after over 10 years of developing this and granting permits, right before all of these companies that were granted the permits could start using them, the government of Ontario announced a moratorium on all offshore wind use because they weren't sure anymore if it was environmentally safe. So their reason was they wanted more environmental assessments, but it kind of left people like Windstream high and dry. So you have on the one hand the need for further environmental assessment was the reason for stopping this, but you also had, even in this case, people from the Ontario government gave them, at least they say in their claims, specific promises that their contract would go through and that this new measure about the environment would not impact their existing permits, which it ended up doing. Then you have an added complication that the moratorium in Ontario was not done legally through the Ontario legislature. They announced it and then just stopped all permits and didn't let any of them proceed, but it never actually passed any sort of legislative body. Then the one people are really liking to talk about right now is this fracking case. Fracking is a huge debate surrounding its environmental efficacy, but not only that, we have a case involving, again, a specific permit. Lone Pine is an American-ish company. Arguably, a bunch of Canadians established a company in the US just so they could use NAFTA rather than using Canadian courts, which is yet another debate about investment agreements. But people have used Lone Pine to say that you're allowing one company to stop the government's decision, in this case, the government of Quebec's decision about fracking and whether it's good for the environment. But in this case, Lone Pine was they had an exploration permit for 4 years at least, explore the St. Lawrence River to decide if they could get shale gas from underneath for fracking purposes. So within the next couple of years, maybe hopefully within the next year, we will see these two cases resolved, either settled or decided on the merits about this relationship between a government's ability to regulate the environment versus investor rights. And my prediction, as I've said, the cases depend not on how good the idea of protecting the environment is, but the specific investors' assurances or promises given to them, and not the law itself and its subject matter will determine it. And that's the end. 'Cause I didn't have a finishing slide, but my conclusions are, who brings these cases? Everybody, and not just Americans. And who wins these cases? People that are smart enough to go and target a specific act by the government violating a promise given to them, or if you're able to prove protectionism. If you go after the law itself as a per se violation, you, at least under NAFTA for right now, would not succeed and have not succeeded. Now I'm open to questions.